A great English poet, Lord Tennyson, is lamenting over his being true to his wife amidst all of his sufferings. Notwithstanding all of his sufferings in the world, he wants to be true to his wife and he invites his wife to be true to him. He says, "O love, let's be true to one another, for the world which seems to lie before us like a land of dreams, which hath neither joy, nor peace, nor certitude, nor hope. And we are here as on a rotting plain where ignorant armies clash at night." Dear friends, I'm presenting this paper for your understanding. Arbitration and its relation to family laws. It starts with an introduction. Arbitration is a divine function. Arbitrators are God's people. Apostle Paul is in support of arbitrators being appointed in the church to decide on disputes among the church members. Arbitration is well seen in the Old and New Testaments of the Bible, and thus the formal non-judicial arbitration first began with the history of the Bible. In the New Testament, Jesus Christ speaks of arbitration, judiciary as well, and it can be said with some certainty that arbitration as a way of resolving disputes predates formal courts. It developed among the nations with the diverse enactments and with the principles on which the popes claimed the right to arbitrate based on the Bible theory of the relationship between the Holy See and the temporal powers. Arbitration is one kind of alternative dispute resolution, that is ADR. Jerry Barrett says in his article, arbitration, an ancient process and modern procedure or practice. Probably few current ADR practitioners know the long history of peaceful conflict resolution. Many may be surprised to learn that the three basic forms of ADR, negotiation, mediation, and arbitration, first appeared centuries before the birth of Christ. The numerous descendants of these basic procedures continue to grow and expand, and finally came together under the ADR title in the late 20th century. The term negotiation usually refers to the give and take conversation between disputing parties without the assistance of a third party. Mediation is a negotiation that is assisted by a neutral third party facilitator with no decision power. In mediation, the final decision on outcomes remains in the disputant's hands. Arbitration uses a third party neutral who decides the outcome of a dispute between two or more parties based on evidence provided by the parties. Often the decision is binding on all parties. ADR is a way for people to try to work out legal issues without going to courts. In arbitration, you or the other party to an agreement, or both of you hire a third person to resolve your conflicts. The person is called arbitrator or arbitral tribunal. Arbitration is different from mediation or private agreements. In mediation, a trained mediator helps people come to an agreement. If you are in mediation, your choices. You can end the talks at any time or decide not to accept what the other party is offering or the mediator is suggesting. In arbitration, you have no choice. You must accept the arbitrator's decision as long as it follows the law. The private agreements made for a decision about a dispute by elders or experts or religious heads not being appointed as arbitrators, their decision is not legally binding and cannot be enforced. Arbitration is like court case, but it is less formal. Most people have a lawyer. At the hearing, both you and the other party can give evidence and say what you think is fair. After each of you has talked, the arbitrator will make a decision. His binding decision is called arbitral award. Arbitration and Conciliation Act 1996 is the statutory law for arbitration in India. Normally, arbitration is used for the right in personam, which is an interest protected solely against specific individuals. Generally, all disputes relating to rights in personam are considered to be arbitrable, and all disputes relating to rights in rem are required to be adjudicated by courts and public tribunals. They are therefore considered unsuitable for private arbitration. There are, however, exceptions to this rule. Disputes relating to subordinate rights in personam rising from rights in rem have always been considered to be arbitrable, such as the family dispute being arbitrable within the latitude allowed in the law. Albeit, an arbitrator cannot grant a divorce or an annulment, but can decide on certain other things, such as how to divide property. They can only decide on issues you ask them to resolve. A cautious explanation of arbitration law might begin with acknowledgement of the tension between two sets of people. First, courts should offer effect to arbitration commitments concluded through informed consent. Second, judges must monitor arbitration. It's a basic procedural integrity which includes impartial arbitrators who hear before deciding and respect both contractual limits of the authority and relevant public policy. On 11 and 12 December 2015, Indian Council of Arbitration, that is ICA, conducted an international conference on arbitration in the era of globalization at New Delhi, where the Honorable Chief Justice of India said that the integrity of judges could be easily accepted by the courts when judges involved in arbitration, whereas other arbitrators' award may be questioned by the courts for want of integrity. But the ICA President and the Advocate General of India, Mr. Mughal Rohatgi, said that arbitration is not the monopoly of the judges and integrity is not their birthright only. These statements reflect the tension between two sets of prospects being set forth below. If integrity were to be looked upon as an exclusive monopoly of judges, there would be no effect to arbitration commitments via informed consent, and the liberty offered to a party through the act to select his own judge, arbitrator being a judge of party's choice, shall be set at naught, notwithstanding the impartiality of the arbitrators, respecting both contractual limits of their authority and relevant public policy. The role of arbitration law thus aims to enhance the rule of law in its broadest sense, seeking balance between respect for parties' agreement and correlative judicial duty to monitor fairness in the process. Today, there is a strong tendency in public policy towards alternative dispute resolution processes such as arbitration, authority and jurisdiction of arbitrators. All matters which may form the subject matter of the civil litigation affecting rights, or in other words, all disputes between parties relating to private rights or obligations which civil courts may take cognizance within the meaning of Section 9 of the Civil Procedure Code 1908 may be referred to arbitration. Pure question of law may be referred to the decision of an arbitrator. Unless forbidden by the statute or public policy, all matters of controversy or litigation, whether of law or of equity, jurisdiction can be submitted to arbitration. Where the parties specifically agree to refer a point of law to the arbitrator, such points should be decided by the arbitrator on and not by the courts. But in the absence of such agreement, one party cannot insist on the other to refer a pure point of law to the arbitrator, and this should be no bar to a party to institute an action in a civil court for a decision on the points. jurisdiction and demand for family arbitration. Considerable degree of latitude is allowed to arbitrators in settling family disputes. They may award to a party the expenses of his marriage. A dispute of civil nature between a man and his wife or between family members may be referable. Arbitrators are competent to give awards in all cases of breaches of contracts, including breaches of promises of marriage. In History Boy versus Beverly Beer, the court observed it has been held by a bench of this court that there is no bar to refer to arbitration under the provision of Schedule 2 of the Civil Procedure Code, a suit which relates to a personal rights between the parties, example, a question of marriage, which is cognizable by a civil court. Parties may refer to arbitration whether a judgment has been properly obtained, whether it has been satisfied, or whether it is void or erroneous. In Umar versus Datley, the court said, the main point argued before us in this application is that the learned sub-judge had no jurisdiction to refer the matter to dispute in the suit in question to arbitration, that such a reference amount to a contract which was opposed to public policy and that is in against public policy, and that suits which relate to the personal relations between the parties should be referred to arbitration. The learned pleader who appears for the applicant has been enabled to refer us to any authority directly on the points. He has referred, however, to certain passages in the law of arbitration by Gopal Das to the effect that the matters covered by the Divorce Act or the Insolvency Act cannot be referred to arbitration. We do not consider that there is any analogy whatever between the proceeding covered by the aforesaid acts and suits by a civil court to which the provisions of the Civil Procedure Code apply. Paragraph 1 of the second schedule of the Civil Procedure Code, section 26, states in perfectly wide terms that any suit may be referred to arbitration. We do not think that, therefore, there is any substance in the point raised by the learned pleader. The question whether the particular claim is within the arbitration clause is a question which, under suitable arbitration clause, is for the arbitrator to decide. Today, many couples in relationship disputes require help in resolving their dispute, but hesitantly, they do not like to go to court. A decision is to be arrived at. Arbitration has significant merits. Problems experienced with adversarial system of litigation. The Supreme Court in the Gaurav Nagbal versus Sumita Nagbal case emphasized that efforts should be made to bring about conciliation to bridge communication gaps to prevent people from rushing to courts. Notwithstanding this recommendation by the Supreme Court of India for conciliation, which is another form of ADR, we are constrained to litigate to resolve family disputes. Let's analyze the best mode of settlement in the light of words of the great people of the world, starting with the most influential person of the world. Jesus Christ said, therefore, if you are offering your gift at the altar and there remember that your brother has something against you, leave your gift there in front of the altar. First go and be reconciled to your brother, and then come and offer your gifts. Settle matters quickly with your adversary who is taking you to court. Do it while you are still with him on the way. Otherwise, you will be handed over to the officers and then put in jail till you pay off the money that you owe to him in full. Mahatma Gandhi said, I realized that true function of a lawyer was to unite parties. A large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. Abraham Lincoln said, discourage litigation. Pursue your neighbors to compromise whenever you can. The nominal winner is often a real loser in fees, inexpenses, and waste of time. Chief Justice Warren Burger of US Supreme Court stated, our litigation system is too costly, too painful, too destructive, too inefficient for the truly civilized people. Family laws and matrimonial mediation. In India, Section 5 of the Family Code Act 1984 provides provision for the government to require the Association of Social Welfare Organization to hold the family court to private settlements. Further, Section 9 of the Family Courts Act, Section 89 of Order 32A of the Code of Civil Procedure 1908 make it obligatory on the part of the court to give a fair chance to a conciliated or negotiated settlement before adjudication is embarked upon. Section 23 of the Hindu Marriage Act 1955 concentrates on attempting a reconciliation by the judge. The Supreme Court's landmark verdict in Jagroi Singh versus Birbal Kaur against ex parte proceedings without attempts to a reconciliation on account of the absence of a party makes it clear that the court enacts to ADR mechanism is mandatory under Section 23(2) of the Hindu Marriage Act, and as nowhere is said that private ADR mechanism would not complement any of the Honorable Court's procedure. We can therefore extend cooperation for reconciliation by all means. Justice Manju Goyal says about the singularities of family mediation, as mediation is in the context of matrimonial dispute is different in its form and content from that in the context of commercial and property disputes. The matrimonial disputes are distinct from other types of disputes on account of presence of certain factors which are not obtained in other disputes. These factors are motivation, sentiments, social compulsions, personal liabilities, and responsibilities of the parties. The views of the two parties regarding life in general and to the institution of marriage in particular, the security for the future life, so on and so forth. Talking in terms of the mediation for matrimonial disputes, one must remember that the factors that weigh the decision of the parties are not controlled simply by rational factors. Very often, irrational and emotional factors also have dominant roles in creation of dispute as well in the settlements. He adds, saying, the professional mediator not attached to court does not enjoy the power of commanding a party to his presence. Here, he must secure the cooperation of the parties by assuring the party that the parties have the freedom to join the mediation but also to terminate it at any time if they feel that the same is not likely to produce any results. This could be done based on Section 62 of the Arbitration and Conciliation Act 1996, which came into force before the Family Court Act in 1984. Family law and arbitration. Its advantages and Christian approach. I would say that the family law arbitration only would say greater damages in the families when there poses a damage in the relationship and social hardship in their divorces. The arbitral awards could direct them to approach the concerned courts for divorce within a stipulated period of time, lest the posing problem should become greater. This would also help the concerned courts to proceed further in a faster pace, using the learned arbitrator's award. Only thing that would matter here is the qualification, training, and experience of the arbitrator and nothing else, though he is a private arbitrator. Justice Manju Goyal, Judge, High Court of Delhi, in his article, advises the mediator or counselor, that's legal conciliator, to bring about a reconciliation or to attempt a separation after the problem is diagnosed, and suggested that the mediator should help the parties to go for immediate divorce if the problem poses greater damage. Having in mind the terms and conditions of the divorce, which may include the question of maintenance, custody of children, arrangement regarding property, etc., in spite of their reluctance of separation, divorce, fearing the society, and so on. What the Honorable Judge Manju Goyal suggests can possibly be achieved through MED, or that is mediation with arbitration or arbitration. Most of the couples in relationship disputes need help in resolving their disputes, but understandably, they don't want to go to courts. Sometimes it proves impossible to reach an agreement even with the benefit of a mediator or conciliator or settlement-oriented solicitors amidst the furies of the couple. A decision is needed now quickly. Arbitration has considerable merits, including flexibility of resolving disputes, choice and continuity of the arbitrator, speed, confidentiality, and other benefits. The advantages and benefits of family arbitration include the following: identity of the arbitrator, continuity of the arbitrator, geographic limitless arbitration, usage of information technologies in arbitration, flexibility of appearance, dispute and timetable for arbitration, privacy and confidentiality maintenance. The arbitrator can deal with discrete disputed issues and deal with all of the cases. The couple control the style of the proceedings, having regard to the nature of the dispute and to their precise needs. The arbitrator is not bound by all rules of evidence, but may inform himself or herself on any matter in any way that she considered appropriate. The arbitrator may require a person to attend to give evidence or to produce documents in accordance with court rules based on powers in Arbitration Act. An arbitration need not be adversarial, which the court-based system still at heart. The arbitrator is more of an inquisitor with power to order disclosure of what is particularly needed in specific case. The parties can decide if costs follow the event. That is, example, who wins? If so, what is the event? Alternatively, costs can be shared equally or on order as to cost. Another advantage of arbitration in family laws is the early neutral evaluation, that is E&E. Being conducted by the arbitrator is used for arbitrators' decision making. Family law arbitration, especially for Christians, would help the couple to dispute to get rid of their feel of guilt of approaching the courts for divorce in the absence of adultery. The Christian priest as a Christian arbitrator can administer oath in his capacity as a priest, being entrusted with powers for Christian marriage, knots and ties, on the ground of ceasing to be a Christian by conversion to another religion, with a biblical exception clause rule, to direct them to approach the court of law for divorce. This would help the lawyers and judges speed up the court processes. It would be more helpful to Roman Catholics who encounter the ecclesiastical process pursuant to the canon law in the churches too. The Indian Christian Marriage Act in 1872 in Part 7 under penalties in section 66 clearly implies that the Church of England or of Scotland or of Rome is a court for the purpose of dealing with the section 193 of the Indian Penal Code 1860, like any other tribunals, as that of a Tahsildar being approved as a court for the purpose of mutation proceedings, though it is not clear enough in section 195 CRPC 1973, where the procedure for section 193 IPC is specified. And approaching the concerned honorable courts, government departments and other experts to clarify section 66 of ICMA 1872 response awaited. If the above mentioned churches are not the courts for the purpose, there are then arbitrators who are, according to the Oaths Act 1969, empowered to administer oath, being not a court as in section 3 of Indian Evidence Act 1872. Whatever be the term, the church can administer oath or receive evidence as per the Oaths Act 1969, being endowed with such power to conduct marriages under oath. This being as such, the church can apply to the magistrate to conduct a trial of perjury under section 340 CRPC, read with 195 CRPC, if it were a court for the purpose or an arbitral award favoring the wrong party in the marriage, victim to the marriage, directing the to conduct proceedings under 200 CRPC before the magistrate for a punishment under section 193 of IPC, if the church were not a court. In this juncture, the church can also issue an award directing the offender to offer mutual consent for divorce to be filed before the concerned honorable court of law, as he has entered into marriage with false declaration, oath, without which the church would not have solemnized marriage. This is a question of marriage which can be arbitrated by the church itself. Biblical rule of separation by the consent of parties. Do not deprive one another except with consent for a time, that you may give yourselves to fasting and prayer, and come together again, so that you will not be tempted because of your lack of self-control. But I see this is a concession, not as a commandment. This rule is accepted by the court of law if consent is put in writing, as in Venkateshwara Rao versus Surya Kumari. Again, this agreement may also invite the pivotal role of an arbitrator for a smooth functioning of married lives in Christian families. Biblical rule of marriage and divorce. For the married people, I have command which is not my own but the Lord's. A wife must not leave her husband, but if she does, she must remain single and else be reconciled to her husband. And the husband must not divorce his wife. This is an implied religious rule of marriage in Christianity, an accepted